Ms. Corley graduated from Ball State University with a BS for a double major in English literature and political science. Following graduation from undergrad, Ms. Corley served a year in the AmeriCorps in Public Safety Division. Ms. Corley obtained her Juris Doctor at Drake University School of Law. So without further ado, you can stop hearing me chat. I'm going to hand it over to Ms. Corley, and I know that you guys will enjoy.
Andrea, thank you for that very generous introduction. I want to thank everybody who has chosen to participate in this breakout for participating, and I'm hopeful that I give you something valuable to take away for yourself and for your community. It's really hard. Oh, I think I was muted there for a minute. So I'll say, Andrea, thank you very much for the introduction, very generous and very kind. Thank you all for joining this workshop. I'm very hopeful that you get something meaningful and worthwhile for yourself and for the community that you'll go back to. I know that many of the participants, you are not in Indiana, you're from all over the country, but I'll use Indiana often as an example and try my best to extrapolate to other communities as well. You know, it's interesting, we are, no matter where you sit, no matter where you are, no matter what you do, I think we're all going through a really challenging time right now. And the fact that you're in the position you're in, reaching out to support and help your constituents, to help people, is just tremendous. So thank you for your service wherever you sit. With that said, I've been focusing on, and I'm sure you all have been too, of the social press that we're experiencing right now for justice, for not just justice, but for equality under the law. And all the communities across the country, I'm sure all of your communities are examining that question of, and how do we use the criminal justice system to bring about equity, to bring about peace and safety. And as we've been engaging in that discussion, there's been a lot of focus on policing, you know, reevaluating what should we be expecting of police? What should we ask police to be doing? And how, if at all, does that need to be revamped, and what should that look like? The same for prosecutors. We look at prosecutors and we wonder, is prosecutorial discretion, is it working? Are they using their authority, their power to do what is actually beneficial for our communities, to keep us safe, to keep us thriving, to help those who have violated the law get back on their feet and join positively into society? Well, I want to encourage those conversations. Those are absolutely needed conversations, absolutely needed dialogues that should be going on right now. But I want to encourage that as those questions are going on in your community, and that as you're a part of it, that you bring public defense into that conversation as well, that you put an eye on public defense in your community. And I'll make a case for why I think it's incredibly important. So that'll be the start of this presentation, is to make a case for why public defense is critical and why it should be included in your community dialogue, and how you can, in your community, advocate for, monitor the success of public defense and why it's important. From there, I'll talk about criminal justice reform just lightly, so that it's applicable to all of us, but just things that you should be looking for and ways that you can engage in your community. I will, after that, focus on some Indiana law changes that probably many of your states have experienced as well. And then from there, just talk about lightly touch on collateral consequences. As I go through the presentation, Andrea will help me. If there are questions, I welcome questions as I'm presenting. I want this very much to be helpful. So feel free to interrupt me with questions and I'll answer them as best I can. So I want to start with our common pedigree. No matter where you live in the United States, the Sixth Amendment provides to all of us, every person, citizen or not, every person who's charged with a crime in the United States, with a right to counsel. Seems fundamental, seems basic. But believe it or not, until very late into our American pedigree, that right did not mean that the government helped you with counsel. So many people were charged with criminal offenses, all of which could result in a loss of freedom, but they had to face them alone with no one helping them, no one advocating for them. That was true until Gideon in 1962. So what I just said was the case until 1962. And Gideon v. Wainwright, Mr. Gideon was charged with a felony. And Mr. Gideon appeared on his own by himself, an elderly gentleman, to defend himself against a felony in the court of law. I'd like to read to you a quote from Gideon v. Wainwright that I think is very illustrative of what the court thought about the Sixth Amendment and what needed to be changed. The court said in its opinion, quote, "Reason and reflection require us to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided to him. This seems to us to be an obvious truth," end quote. Amen for obvious truths. So from there, we have the right to counsel that everyone in the United States has a right to if you're indigent. It will be provided to you. Second, that was just for felonies. Well, second, it took Argensinger as the next case to say it should apply to every case where you could lose your freedom. So not just felony cases anymore, now misdemeanor charges for sure. So that was a very clear, just foundational principle. The next two cases, Strickland and Chronic, say not only do you have a right to counsel in any case where you might lose your freedom, you have a right to competent counsel. It's not enough to have a warm body sitting next to you. There are some horrible cases where literally defense counsel was asleep, not doing anything. Cases like Strickland and Chronic make clear that that is unacceptable. And so there becomes a right to effective counsel in addition to having counsel. So that's our common American pedigree. But from there, one has to wonder in your own community, well, then how is that provided? What rights does it extend to? So here I'm going to focus on Indiana, but this is likely common in your community as well. So to back up, law is divided into law is made a couple of ways, two ways. By statute, meaning your legislature comes together and they vote on a piece of law, and that's the law. The other way is what we just looked at, the case law that comes from the courts. In most cases, even in Indiana and other states, there is no statute that says, in these instances, here are all the ways you have a right to counsel. Generally, that doesn't happen. It happens by case law. And so in Indiana, we have our own unique case law that has brought about rights beyond just the criminal. So in Indiana, and this is true likely in your state as well, you have a right in criminal proceedings, as I said. You have a right in juvenile delinquency. And you might be thinking, well, juvenile delinquency is criminal, so that's duplicative, Bernice, you didn't need to say that. Juvenile delinquency is actually not criminal. Technically, it's a civil proceeding. And normally, you don't have a right to counsel in a civil proceeding. But because a juvenile could be taken, their freedom could be taken away from their family, court, there's case law that says that juvenile kids in the juvenile delinquency system who are indigent have a right to counsel. It goes on, chins, in Indiana, that means that a parent could lose their child. So we're not talking about freedom anymore, but we're talking about a fundamental right to parent your children. You have a right to counsel there. Same with termination of parental rights, appeals, post-conviction, involuntary commitments. So if there's a person who the state believes the person has a mental health illness such that they are a danger to themselves or someone else, and they could potentially be detained in a mental health facility, they have a right to counsel as well. And then finally, child support contempts. That is a civil proceeding as well, but one can lose their freedom for violating a court order to pay child support. So in Indiana, you have a right to child support, a right to attorney in a child support matter. Now, I stress that this is case law because it gives me a bit of hope. There are many areas that you can think about as you're helping people who are indigent, that it would be nice if they had a right to counsel. When you think about evictions, when you think about civil forfeiture. So if the state has charged you with an offense and they think that you've used a vehicle as part of that offense, and the state tries to obtain that vehicle. In Indiana, you do not have a right to counsel to help you with that case. So it's you arguing against the state in a civil proceeding that that item shouldn't be taken away from you. So it's my hope that we'll continue to press to advance and broaden the right to counsel, even in civil proceedings, because if the point is equity, if the point is to balance the playing field, then it's essential to have representation in these critical areas of life, such as housing and property ownership. So here, it just is a very helpful quote from Justice Hugo Black. And we in Indiana, and many states have had this, I'll provide the resource further on in the presentation. But we had an examination of our public defender system by the Sixth Amendment Center. And Indiana did not do so well in our review. When this outside organization looked at Indiana, and it was a very lengthy report, so I've only highlighted a few things, we were cited as having significant delays in our initial hearings. And I'm going to collapse this because I can't quite see my own. There we go. And that individuals were remaining in jail without having representation appointed to them. We also were cited that individuals were encouraged to plead guilty when they were never given an attorney to talk to or counsel to about that. Also, there was a lack of uniformity in whether someone was even indigent as to whether they should be appointed counsel. And then finally, there were individuals who were determined to be ineligible for a public defender simply because they posted bond, which is actually against Indiana law. So what's interesting here, and a takeaway that I want you to see, is that the law may be one thing. People have a right to counsel. We should feel comforted in that. But law can be administered in such a way that people are constructively denied that right to counsel, because a judge might pressure a person in a misdemeanor case to say, hey, the prosecutor wants to work out a deal with you. Why don't you go talk to him and get it all worked out? And without knowing any better, without having any counsel, people do that. And so this is a reason why it's important in your state, wherever you are, to, yes, know that there's a right to counsel, but how fundamentally is it actually being implemented? In Indiana, there are tremendous disparities. I use some older numbers here. But when you look at total cases filed and public defender appointments, there's pretty close alignment. And obviously not every case that's filed, not every person is indigent. Some people have to hire their own counsel. But I want to point out or drop down to CM, that's misdemeanors. In misdemeanors, the volume of cases is tremendous, over 140,000 in that year. Well, look at the very small appointment. That very small appointment tells me that the Sixth Amendment Center was right. In Indiana, we have a lot of people who are being brought into court. They have a right to counsel, but for whatever reason, they're not being appointed counsel. Because there's just, based on my experience, there's no way out of the 140,000 that are filed that many people are hiring their own counsel. And when you couple that data with the Sixth Amendment report, we have a real breakdown, especially in misdemeanors, of people who are not represented by counsel. And that might seem like a small thing, but I will provide you a resource later to look at collateral consequences And a conviction on a misdemeanor can have tremendous implications in your life that will follow you for the remainder of your life. So misdemeanors are really something that have to be paid attention to in that matter. So next, I'm sure I want to cover with you how public defender funding works. When you think about Gideon v. Wainwright, it's a federal opinion, it's a Supreme Court opinion. It says that there has to be a representation for people who are facing felonies, and then it goes down to misdemeanors. With that said, however, there is never, ever a funding mechanism set up at the federal level to provide funding to states to provide representation. So there are many who have written of Gideon that Gideon's promise really is unfulfilled because there's no funding to go with it. There's no structure on how to structure public defense in states. So there are many who say Gideon is great, but Gideon, the reality of it has never been realized. And so since it's the law, it's required, states do it. And states do it largely with either state funding or a mixture of state and local funding. Indiana is an example of that. And then the next is minimal or no state funding, meaning it's all county paid for. We can imagine how with this varied sources of income, some counties having the decision of, do we pay for schools or do we pay for public defenders? Obviously, we can think about with all of the competing interests for public funds, people who are charged with crimes are not the most sympathetic people that lawmakers want to spend money on. So public defense, no matter where you sit, except maybe DC, the District of Columbia, are really seriously underfunded. So that's something definitely to be aware of. This table provides some examples of just breakouts. There are many states that are state funded. So you have those up top. You have the mixed funding, which is a smaller group. And then just a few that provide basically county funding at the bottom here. So just to give you a sense of how things work in your community. As I shared, that Indiana is a county-based fund, county-based state fund. And this is how it works. This is an example of a system that doesn't work entirely well. So in Indiana, we have 3 state public defender agencies. There's my agency, there's a public defender commission, and the state public defender. The purpose of the commission is the commission has state tax dollars that sit with the commission. And the commission offers to every county in Indiana, there are 92. They say to the counties, if you would like some help paying for public defense, we will give you 40% reimbursement on your felony cost and 50% on your death penalty cost if you join us. And by joining us, what that means is there are going to be standards for how many public defenders you hire for your county to make sure that they have adequate caseloads and they're not, overburdened, and that they can actually do an effective job. It's going to require that you provide support staff to them, paralegals, investigators, as well as training requirements. Now that if you join us, that means you can't have a new lawyer having a death penalty case. We're going to have standards that you have to follow. And so there, at this point, about 65 of the 92 counties have said, okay, we'll join and we'll follow your guidelines and we'll take the 40% reimbursement. For a county like Marion County, where Indianapolis is, that means millions of dollars back to that county. It's a tremendous help for sure to that county. But then you have counties that won't join. And this is Bernice talking, but we have to assume they won't join because they want to follow their own dictates. And so they'd rather fund it entirely themselves and have no oversight at all than to take the money from the state and be subject to the standards by the state. What that means is you have a wealthy community like Hamilton County in Indiana is, I think, one of the wealthiest counties. So Carmel, Indiana is there. They are not in the commission. They don't want the state's 40% because now they get to decide entirely how their public defender system is structured, how many cases that they will give the person, et cetera. Then you have rural, more smaller counties that it's probably a lot of money for them to pay for public defense entirely on their own. But what they get in exchange is some of the judges in those counties, all the judges in those counties, they hire the public defender. I'm going to repeat that. They hire the public defender. So imagine having a public defender that is hired by the judge. That is the person who decides if they continue to work or not. And that same person has to advocate and fight for you, whether it be fighting for your pretrial release or fighting for you on a motion to suppress evidence against you because of an illegal search. These are all very combative proceedings that when the judge is your boss, there's an obvious concern of independence. And so when you see these sorts of funding mechanisms, when you see counties where, excuse me, the judge can hire the PD, it leads to a system that is not nearly as robust as it should be.
Bernice, I had a question.
Please.
I appreciate you breaking this down because I'm really able to understand it, to be able to reflect on it. I'm baffled that the funding, I didn't realize that the funding came from the state level. What would it look like if it was at the federal level? Do you think that, what would that look like?
Thank you for bringing that up. I meant to cover that. So there are national defender organizations who have been advocating for the federal government to offer to each state an apportionment based on caseloads, based on filings, funding, and to basically do what Indiana's commission does, require states that when they receive this money to have certain standards to make sure that the attorneys have caseloads that they can manage and fully work. But there just has been, Andrea, no appetite for that at the federal level. The only PD agency that receives federal funds is the District of Columbia, DC. They are incredibly well funded, and they are one of the shining stars of what public defense should look like in this country. And I could go on about them. They're incredibly impressive, but they also are the ones that benefit from federal funding. So that's how we would want to see it, Andrea, is strings attached, not just give the money, but give the money and require that there be, supervision, caseload standards, et cetera. Does that answer your question?
It does. Thank you so much. That leads me to another question. As far as the prison system, now, is that federally funded? I know we have federal prisons, because my thought is, okay, we're going to federally fund prisons, but we're not going to federally fund to allow citizens to be able to have a defense.
So in Indiana, we have some state and federal prisons. So if you are charged with a state crime, then you are in a state facility and the state does pay for that. But then there are federal facilities. We have one in Terre Haute, for example, that if you're charged with a federal offense, that's where you're gonna sit, and the feds pay for that.
Okay. I'm gonna go out on a limb and assume that the prison system doesn't have any challenges getting the funding that they need, as opposed to public defenders.
I will say the Department of Corrections has a very sizable budget in most states, and Indiana is not unusual in that, for sure. And actually, Andrea, to make the point, when someone is charged federally, the federal public defender is paid for by the federal government. And so they are much better equipped, much better resourced than any state, county-based public defender program.
That leads me to another thought.
Mm-hmm.
In most cases, if you're in a federal prison, those are not going to be your typical crimes like manslaughter, but is it going to be more white-collar crimes?
So it actually can be across the board, really. I'm trying to think of some examples. I mean, you can definitely have people who have committed murder in federal facilities, charged federally. Think of the Oklahoma bomber, Timothy McVeigh, who was housed in Terre Haute for years. So drug dealers, if they've crossed state lines, if they are in part of an enterprise that cross state lines, they can be charged federally instead of state.
Okay.
So I've kind of covered this already. I'll skip forward, but start investigating your county structure. And actually, I missed a point I wanted to make before. The reason it's important for, as you're engaging in discussions about criminal justice reform, to look at public defense across the nation, nearly 80% of criminal filings, they're represented by public defenders. So if you have a weak public defender system, or you have a system where it's underfunded, such that they're not giving public defenders to people who are charged with misdemeanors, then you have a real problem in that community. You're gonna have poor people who are gonna end up with more convictions, harsher sentences, harsher placements than if they had had proper advocacy.
Bernice, we do have a question from Liz.
Mhm.
Wants to know, is there a way for us to look up county by county public defense structure?
So yes, and that's a perfectly timed question, Liz. This resource that I have on this page is from the Sixth Amendment Center. So just like Indiana was examined, many of your states were too. I didn't put the list here, but if you go to their website, and it's Know Your State, it will tell you about your system, and then potentially your state is one of the ones like Indiana that was examined, and they break it down. They will tell you how your system works. They will tell you how your system is funded and where your areas are weak and even what counties are weak. So if you want to direct your attention to your county or to your state, if you have a state system, this really, in my opinion, is where you want to start, for sure. Liz, so I think you'll find that resource very helpful. I talked about Indiana's findings, so I'm going to skip ahead a bit. So as I suggested with Liz, start with knowing about your state. And so I'll tell you what happened after we got it examined. So if your state was examined and there was a report, look to see what happened with that report. Was there a reaction from your legislature to try to fix those things? Examine it. I'll tell you what happened in Indiana. And it's a disappointing outcome. And I share this as a learning lesson for everybody. In Indiana, after we got this report, if you care about justice, if you care about equity, it was awful. And so the Public Defender Commission pulled together a task force to work on this issue, to take that report that we received and fix it. And so they wanted to be sure that they got community input. So think about all the people in Indiana who have had public defender representation or are family members of people who've had public defender representation. So the commission funded listening tours around the state. They hired a transcriptionist to be present to take down testimony. They put public notice out. They partnered with local entities, the Urban League, NAACP, and other community resources just to let people know about the listening tours. They solicited for public comment. So if you couldn't attend the public tour meeting, you could submit your experience to just put a face on the injustice that was happening or poor service that was delivered. I have to say about the listening tour and the solicitation for public comment, very rarely did a person come to speak that wasn't already part of the public defender system. I'm not trying to minimize the import of public defender speaking. That's very important. But we also wanted to hear from people who had lived experience that had received the services and what they thought about it, because that's very powerful. And we really didn't get the community feedback. It's concerning, but despite our efforts, we just didn't get the community engagement that we felt like was really essential. So unfortunately, with that said, the commission had to move forward with trying to actualize and come up with solutions, but those solutions were only informed by people who were already working in the system, by public defenders, by chief public defenders, by judges who had, input. Very little came from, we had very little to work with in terms of public engagement. So I shared that as a weak point in our efforts of moving things forward. We tried, but we really did not get liftoff with public voices. And I encourage you, as you know, if this is an area of interest or passion, you know, thinking about how do you get engagement and community voices, because the community changes things. When you can get community force behind an issue, it will influence lawmakers. And I think that's where, unfortunately, we really were not able to get the liftoff we needed. We did develop plans and a legislative agenda and platform, but much of it was not successful. And, you know, for me, I really feel like it was due to a lack of community engagement. In your community, when you are hearing about criminal justice reform, or, you know, often they're talking about these issues, you know, policing and prosecutorial discretion, you know, the decision of who to arrest and whether to charge the person, obviously, are incredibly like the first steps and are the most crucial, definitely. But then there also, you talk about fines and fees, bail, indigent defense, corrections, like how are we using our jail resources, and then reentry and collateral consequences. Generally is that package that you'll see, or all the elements that are covered. In Indiana, our criminal justice reform that really started in 2010, it wasn't that broadly, it didn't cover all those elements. There was very little discussion of policing. There was no discussion of prosecutorial discretion, but instead, lawmakers really seemed motivated on these areas here. Indiana was facing, in 2010, there was a prediction that we were facing an exploding jail population. Prison population, such that Indiana was going to have to build another prison. And so that really became the motivator for Indiana to move on criminal law reform. So when you think about it, if that's the objective wasn't necessarily, I'll just say the objective was what was stated, which was how do we deal with the erupting jail population. And so with that, Indiana pulled together some stakeholders. And here's, I pulled this from a presentation on the reforms. These were the stakeholders that were there, and they're all good. They all should be there, that's right. But there's an obvious group that's missing, and that is people with lived experience and people who have been involved or on the receiving end of this criminal justice experience. And so those groups just weren't engaged. They weren't invited to the table. They weren't present. And I'll share why I think that's important later on. So the result of one of the main outcomes of Indiana's criminal justice reform is that it significantly reduced drug offenses. However, if you, and those changes came into effect in 2014, the significant reduction in a sentence. So I'll just focus on that as an example. But the changes in the the drug sentence, those changes were only prospective. They could not be applied retroactively. I want to dig a little deeper in that. Indiana did create this opportunity for sentence modification. So if you were sentenced before 2014 and the charge for which you were sentenced was significantly reduced, theoretically, you could apply for a sentence modification. But here are the road bumps. For a sentence modification, if you're in DOC, you don't have a right to counsel for a sentence modification. So you have no one advocating for you. Yeah, you can write a letter to the court saying, hey, I think I should get one, but there's no one to advocate for you or anything to happen with that letter. Additionally, if your matter was resolved by plea, if you agreed, and let's be clear, around the United States and in Indiana, most matters are resolved by plea. So if your matter was resolved by plea, you were not able to get a sentence modification. Third, in many instances, the prosecutor had to agree to you being able to file a sentence modification. So this really, in practice, is not a tool of justice, of equity. So there are thousands of people who are still in the Department of Corrections serving very long sentences on offenses that have subsequently been reduced drastically. Now, I think that's unjust, and I think most people think that. And I feel like this is that if there were just people with lived experience at that table, at the policy table, that maybe this sort of retroactive prohibition would have looked different, and that maybe the changes that happened would have been applied retroactively. If the goal really was to reduce Indiana's exploding jail population, then it seems like this would have been an obvious thing to address.
Bernice, you have a question?
Yes.
Excuse me. What is the difference between a prison and a jail?
So, and I think this is consistent across the United States. A jail is generally funded by county resources. Additionally, a jail is generally only used to hold somebody pre-trial if they're not released, or for a very short sentence, like a year or less sentence. A prison generally is state funded. And I think that's true across the United States. So those are state dollars that are funding that. And they're generally for people who have a longer sentence, longer than a year to serve. Additionally, because people are there longer, prisons tend to have more rehabilitative programming than a jail does, because jails are seen as more short-term. So a point I'd like to make on this slide before moving forward is when you have public defenders, like our counsel is going to be advocating for changing this, reforming this, and we're working with lawmakers now. It's a tough sell, but we're trying. But that's the benefit of having a strong public defender system, is that they can be lobby, they can have a lobbying function to try to mitigate these really harsh penalties. So now I'm going to go into reentry and some law updates. They're not entirely across the board for everybody, but I'll just lightly brush over them. Just to know, in Indiana, effective July 1, so if you're traveling through Indiana or you live here, we are now a hands-free state. You cannot operate a vehicle and use a phone at the same time. They built in a grace period so that if you're stopped by police for holding a phone while you're operating a vehicle, you will not be cited for it. You will not get any points until July 1, 2021. So this is kind of a grace period to get our citizens aware, or people aware of the law here. Obviously, there are a couple exceptions. Next is, and driving is a big issue on reentry, right? And this is very helpful. 1157 allows a court to give or require an ignition interlock device instead of suspending someone's license. This is huge. Could be very helpful. So if you have a person who has been stopped or cited for a driving matter, instead of automatically losing their license, this is a path forward where they could still have their license and be able to drive legally, so long as they have the ignition interlock on their car. Let's see, what else is helpful here? I'll drop down to the second point. This is different in Indiana. In Indiana, if you had a suspended driver's license, let's say it was suspended for 180 days, but you entered into a plea before the 180 days was up, and that plea would allow you to have your license back. Well, judges read the 180 days very strictly. So even though you entered into a plea and you should be able to drive again, that suspension stayed in place for the term, for the full 180 days. Now, the court doesn't have to do that. They can terminate the suspension at any time. And I think that's very helpful for people who are reentering or have driving issues. This is just something, before in Indiana, a person who was under 18 years of age, if they got a driving infraction, they could not avail themselves of what adults could, which adults could perform a community restitution or service instead of paying a monetary debt for a Title IX violation. Now 18-year-olds can avail themselves of that. 39, this is very helpful. Again, going back to Indiana judges were very strictly looking at when they did a special driving privilege, it was for the term they said. If it was 180 days or 2.5 years, that's just what it was. But if your matter resolved, you still had a specialized driving privilege rather than just your license back. So this is meant to allow a court to remove specialized driving privileges and restore regular driver's license upon the resolution of your matter, whether it's by plea or however the case resolved. Excuse me.
Bernice, I had a question. I know we are talking about Indiana related laws. What if someone sees a law that's not in their community? How would they take that information back? Do they give it to an elected official and say, hey, Indiana's doing this, how can we make this happen? Is that?
Yes.
Yes, they would go through it?
Yes. So most, let's start by saying most general assemblies around the country have really transparent, great websites. I would start with, so if your concern is about a traffic matter, I would look at the committees, legislative committees that handle that topic. Look at the chair and vice chairs of those groups. Those are the deciders. Those are the people who are obviously in power around that topic. I would then focus on talking to that person. Does that make sense? This next matter I think is really important for people in Indiana to be aware of. This is very concerning. If you are helping someone, a young adult who is under 26 or 28, let's say if that person had a juvenile adjudication for a crime that is a crime of violence, and I have the statute here, it's a very long list of what a crime of a serious violent felony is. But I've given you some examples. If you have a person who as a youth was adjudicated true finding for one of these matters, they cannot, as of I think July 1, have a firearm as an adult. So if they're younger than 26 or younger than 28, depending on the act for which they were convicted. So you could have somebody who was adjudicated when they were 16, 17 years old, and now they're 23 and they lawfully possess a gun. They are now in violation of this law. So it's very concerning. We fought this very hard and lost. So there are some adults who were legally possessing a gun who now, as of July 1, are no longer legal to possess it. They're a serious violent felon in possession of a firearm. So I have the code site there. If you're working with somebody that you know has a juvenile background, this is something to be aware of. And it's really concerning and unfair because I don't know how anybody would have notice of this, but.
It's almost as if they're penalizing the person again. I mean, you committed a crime and, paid your debt to society, and now you're an adult and you're still holding me accountable for something I did when I was a teenager.
Yes, and that violates one of the basic principles of why we have a juvenile system. I mean, we have a juvenile system to protect the youth, understand that they are a youth, try to rehabilitate them, get them on the right track, but that is not supposed to follow them into their adulthood. And so I will tell you the reason we believe this statute was passed is in Indiana, we had a school shooting in Noblesville. And there have been all sorts of bills filed as a result of that one incident. And this is one of them. And the disparate impact that will happen. The child who was involved in the Noblesville shooting was a white child at a predominantly white school. But in practice, this is going to hit Black and brown communities much harder than white communities. But all around, it's just, in my opinion, a very unfair statute. I see I'm running really short on time. So this is about expungement. So if you have someone that you're working with who has a conviction, I'll just say this is an expungement matter. I think the materials are available to you. It's really helpful to anybody who has had a protective order against them. Those can be expunged now. So this is actually a really good, really helpful piece of legislation.
And
it just
Bernice,
goes,
remember, we have the time slated for an hour and a half because we
oh, that's
built
right.
a discussion just in case people had, some questions at the end of your presentation so they could have a really, robust discussion. So feel free.
Awesome. Thank you for that reminder. So in Indiana, there was a Court of Appeals opinion where a person was convicted of a felony, but part of their plea agreement was after a certain time, if they did well on probation, then they would get the benefit of alternative misdemeanor sentencing, which meant at the end of their probation, their conviction would convert to a misdemeanor. So that happened for this gentleman. It converted to a misdemeanor. Well, then he waited the appropriate statutory amount of time to apply for an expungement in Indiana. Well, when he counted the time to see if he was eligible for an expungement from the time he was convicted of the felony. But the Court of Appeals said, no, 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 no. The time started all over again when you were converted to an A. So you are not eligible for an expungement. Well, he appealed that decision and he won. And what was determined is the time is going to start from the felony conviction, not from when you got the A misdemeanor. And this happens a lot in Indiana, that the benefit of an alternative misdemeanor sentencing. So this will be helpful for some people. Additionally, the definition of what a criminal history information was amended to include a protective order. So now when you seek an expungement, you can also seek an expungement for a protective order in every document related to the protective order. So the petition that was submitted in order to support the request for a protective order, all of that can now be expunged.
Bernice, I do have a question. Excuse me. And I think this was to the prior discussion that we were having as far as an adult not being able to have a firearm because of something that's taken place when the person was a teenager. The question is, are they notified prior to, or is the first time they learn about this new law is when they are arrested for what they believe is lawfully carrying a firearm?
It's just what you said. They will not be noticed. So it will be the first time when, let's say they are lawfully in possession of a firearm and they get pulled over for a traffic matter, and law enforcement becomes aware. Supposedly NICS will have these people identified, and the officer will be able to see, oh wait, this is a juvenile who had a serious violent felony adjudication. They shouldn't have a firearm. So that person could very well be arrested from the side of the road for having something that they legally had a right to have. They thought they had a legally right to have. So that's what makes it really disturbing and unfair. So no, there's no notice going out. Let's see. Back to this slide. The law also gives an ability to seek an expungement of collateral actions. So what that can look like is collateral action. I'm trying to think of an example. Now my mind is freezing on me. I can't think of an example. Well, I'll go back to protective order. So let's say a collateral action would be if I got charged with a battery, and then there was a protective order that instantly went into place between me and the person that is the complaining witness. That would be a collateral action. And then also this gives employers who are law enforcement, they can refuse to abide by the employment protections extended for those who receive an expungement. So what that means is if if they're law enforcement, if you're applying, let me back up because many people are not from Indiana who are on this. In Indiana, if you receive an expungement and then you're applying for a job, and on that application, it asks you, have you ever been convicted of a felony or convicted of a crime? If you receive an expungement in Indiana, you can lawfully say you have not. That said, if you're applying to work for a law enforcement entity, that does not apply. You have to tell them the truth, regardless of whether you received an expungement. And that's born out of, I think it was out of South Bend, something bad happened with their law enforcement entity with somebody who had a criminal history that had been expunged. Senate Bill, yes.
Oh, sorry, I do have a question that was in the chat. Before we are in the system, how do we protect and state our rights while coming into contact with an officer?
That is a challenging one. And to tell you how I feel, it's no matter what advice anybody gave to answer that, we have seen law enforcement act in ways that defy it. So look at what happened to Philando Castile. He did exactly what law enforcement officer asked, and did what the officer told him to do, and still was murdered by that officer. I have to tell you, I would be reticent. I understand the question, but the times we're living in and what we're seeing, the violence, it's hard to give you a good answer. It just is. Yeah, I'm not trying to cop out here, but what we're seeing, the violence that's being meted upon people in violation of their rights. But generally speaking, just to give a fundamental, in most communities, if you're asked by law enforcement to identify yourself, you generally have to identify yourself. That's one fundamental. In Indianapolis, not only is there a state law, but there is in Indianapolis an ordinance that if you're stopped by an officer, that you have to give your, like, who you are. So that's a fundamental that's probably true wherever you are. So that's a basic, something that I wouldn't think is worth fighting over, but to go ahead and give them your information. But I'm reticent to go beyond that. I'm very sorry.
And I do have, I think it's more for kind of everyone. Is anyone out there aware of state or local units of government that have hired former offenders?
I think so. And I'll say this, like to use Indiana as an example, we have hired peer coaches in many areas. So in our Department of our Family and Social Services is an umbrella agency that has several underneath it. And so when it comes to like addiction and things like that, they absolutely have hired peer coaches. And they've worked for like in DOC, like they've gone into facilities to help people to lead groups, et cetera. So there definitely are examples of that, absolutely. Anything else, Andrea?
I do have one. It was kind of a comment, but I think it's really great that Treka is bringing this up. She had commented that having this conversation and continuing it is probably a great step in mitigating this issue. So, and I guess this is kind of post session. Is there a way that we can convene or, and that's something we can think about. And I will say this, we do have the email addresses of everyone that's registered. So as we kind of process this after this session, we can, revisit that. But I appreciate you asking that question, Treka, because I think it's great because a lot of times you'll go to a session, you think that was great, and then nothing happens. So yeah. I appreciate that you're thinking, long-term, how can we work on this? So. Absolutely.
Yeah, that's a great question. Well, on the next issue, and this is an issue that all across the state. So in Indiana, we just had a slight change to our Indigency Determination. And that is, we try to make it easier. I supported this language. It is not the language that was filed that I did support, but it moved us slightly forward. It's not as bold as I wanted it to be, but what we were trying for was to have some across the board, very clear guidance to judges of how to find someone indigent. We had some judges that if you came nicely dressed to court, I literally had a judge tell a guy that he should sell his nice leather jacket to help him get a lawyer. I mean, I witnessed that personally, and would not give the person a public defender, even though they were clearly indigent. So the goal of this was to try to stop that kind of thing and just have a uniformed approach for judges. So with that said, if a person is before the court asking for counsel, if they're on any kind of assistance for indigence relief, the judge can stop thinking, like stop asking questions. If they can prove that they receive SNAP or some benefit, that person is indigent, give them counsel. And that's the goal. We're hoping that will make things more succinct and easy for people going forward. In Indiana, now this didn't pass this session, this passed the last session. Court fees obviously fines and costs are a huge burden for people on reentry. We are, when I say we, the Public Defender Council is absolutely fighting this issue and searching for reform. But a good step in this direction is that courts have the authority that if a person is indigent, but they owe fines and costs, rather than violating them and turning it into a civil debt that the person will owe, the court can order the person or convert it to community service hours and allow that person to serve as a volunteer. And the person can choose where they want to serve as a way of paying that back without. Now, obviously, there are a lot of flaws to this. When we think about people who are single parents, who are working 2 jobs, like where's the time to volunteer? We definitely made these arguments, but it still is a step in the right direction. We appreciate that there is this avenue for people. And then something that as you're in your community and you're wanting to stay up on things, every General Assembly, I think in the United States, I could be wrong, but has a time, like generally in the summer, where, well, let me say this, most legislatures are part-time, and the summer is the downtime to study topics. If you have a full-time General Assembly, then this wouldn't apply to you. But be aware of those study committees, be aware of what they're talking about. So here's an example from Indiana. We are a part-time General Assembly and study committees are about to start. So we follow those committees and we provide testimony. As Andrea said, I'm in the Reentry Coalition. I let all the stakeholders who are engaged, I try to keep them informed so they know, so that they can get their constituencies engaged as well. So here, number 8 is very concerning for public defenders, the efficacy and impact of defining sexual consent. So we'll be there and we'll be presenting and talking about that. You know, the next is looking at our criminal justice reform and how is it doing. So those are places where citizens can engage, they can come and they can testify, or you can be part of a group that does the same. The second matter here in Indiana is a huge deal. We have thousands of people who have a suspended driver's licenses and who have like piled on suspended driver's licenses, but they continue to drive because they have to, got to go to work, got to, take your kids places, etc. So we are working on, and I'm actually part of a working group with the prosecutors to work on reform. And so this is a topic that is being studied that we'll be engaged in. So I encourage you, wherever you are, to just have your finger on the pulse of what is of the moment, what is your legislature dealing with. And I would encourage you, if there is an issue that you see from where you sit, you can influence these study topics. In Indiana, it's as simple as writing a letter to the Legislative Council or getting a resolution passed in the General Assembly to have a topic studied. And then there's a whole process on how the topics are selected. You can be a part of that, and I'm sure that's true in your community as well. And here, I didn't want to go into examples because they're so varied, but I provide a resource here. Go to it as you're serving people or working with people, or if you're a person who has been criminal justice involved, look at the collateral consequences that are in your state. In Indiana, so I have to say, not only should you look at the state, but you should also look at your county to see if there's anything unique. So in Indiana, our state has collateral consequences in our state statute, but like in Indianapolis, there are ordinances around collateral consequences, around who can apply to get a contract with the city, who can't, things of that nature. So this is a very important resource as you're working with people to go to and consider. One small example in Indiana, I'm trying to think of an offense, but if you commit a certain offense, there's a whole range of them. You can't even volunteer at a school. So if you were there wanting to volunteer in your children's class or something like that, you couldn't do it if you had certain convictions. So it doesn't just affect work, and it can affect a lot of different opportunities. So with that, that's my conclusion. I hope as you go back to your communities, you will think about public defense as you're challenging other areas of the criminal justice system, because it's very important. America would not be America if you had to face the power of the state without an advocate there with you. So with that, are there any other questions? I'm happy to address those.
Does anyone have any other questions? And if you don't have a question now, again, I did send out the invite. So if you want to email me personally, I can get that information to Bernice. So don't feel like, oh my God, I forgot to ask this question. You do have the opportunity. And then we'll also be sending the PowerPoint presentations for all of the sessions at the end. So you will get that as well. But we don't have any questions in the chat, but I just wanted to thank you again, Bernice. And for all the viewers out there, if you're like me, when she did present at the Marion County Reentry Commission, I mean, I just felt like it was broken down. I felt like I had been to like, you know, it wasn't like over my head. So I do appreciate that. I say that lightly, you know, but I do appreciate that. And just your ability to, for me, put ease. Yeah, it's really true. You put people at ease. And I think, you know, this is such a sensitive topic. And I know we've got a lot of people on here that may have been involved in the system and they just didn't feel comfortable. But I think you have that presence about yourself. So I really do appreciate that. And I do want our viewers to know that to please email me directly. Don't feel like this was your last time to ask a question. We do want to be an advocate for you as well. So please reach out to us. And again, thank you, Bernice. And then,
thank you.
Silas, I will hand it back over to you. Everyone is saying thank you, Bernice, in the chat.
Oh, that's very kind. Everyone take care, be safe.
All right, on behalf of the National Promise Zone Coalition and this first annual National Promise Zone Federal Convening, we do thank you all for participating. We still have a number of presentations going on this week and next week. Please participate as you see fit. With that being said, thank you, and we'll hopefully see you on another presentation. Ms. Corley, thank you for presenting today. And Andrea, great job on moderating.
Thank you. Bye-bye, everybody.